And the recording seems to be working. Okay. Sorry about that, folks. For some reason, I wasn't logged in. Okay, so this is the Zoom recording of workshop number 4 for succession law. And tonight we're getting into the legislation and having a bit of a look around how it all works. So the topic tonight is around judicial powers to preserve wills, and the broader field of the topic is really around that contradiction we started talking about last week that exists in the Succession Act and in the common law as well. On the one hand, we've got some hard and fast principles where the law is applied very, very strictly, sometimes with tragic circumstances for people who thought that they were going to get gifts under a will. On the other hand, there's situations where the courts come in and go, yeah, we don't like that and we'll fix it. And that creates a bit of a problem in terms of certainty. Now, that same problem does exist throughout the law, and it's one of those skills, there's a skill, it's a capability, I think, that you learn as being a lawyer. If you're too rule-focused, there are so many sort of fidgy-widgy grey areas in law that exist to give discretion. And I think the skill of mastering the law is striking that balance between knowing where the rules are hard and fast and then finding the zones where you can try and make an argument around that for special cases and so on. And that's how, the precedent process works. You go to court and you go, actually, I've got a special situation here and I want it to be recognised in law. Okay, so we're going to have a look at that, and we're going to talk a little bit about, I don't know if you've talked a lot about legislation in your course, your program, but I want to talk a bit about legislation. We're going to look at some of the fidgy-widgy areas of the Succession Act. Daniel's saying, is anyone on his internet really bad? Okay. I seem to be getting you guys okay. Hopefully it's recording well. So at the end of the day, if it's too crazy, you should at least be able to listen to the recording again. Although I had incredible trouble last week getting the recording up on Moodle. So what I'll be doing in future, I think, is uploading it to YouTube and then putting a link in Moodle. Because Moodle just doesn't seem to want to upload things. Anyway. I do have some news that I'll put on the site as well. We've got a week before the term break, and the next week and a half I'm going to a conference in New Zealand. But I will be endeavouring to, fingers crossed, log in from New Zealand on Wednesday next week. I don't see any reason why it shouldn't work. Hotel's got broadband, and let's face it, New Zealand's internet's better than Australia's. But I'll put a notice on Moodle. So if everything goes to hell and it doesn't work, we'll sort something else out when I get back. But this may be a chance to see if we work as a global university. I know Stephen tells me he's done this from Turkey. So and again, Turkey has better internet than Australia. So yeah, next week I will be in New Zealand, but things should be happening as usual. The week after that is the term break, but I will be available via email, etc., for questions. So don't feel as though you can't contact me in that time. Okay. Well, let's get on to the questions for tonight. I guess I'll start with a little bit of a preamble around reading legislation. Just a question. Have you talked about legislation in depth in other courses? You can hit the chat line and tell me where you've bumped into legislation before, but I'll presume you haven't done a lot. One of the challenges of using... No, we can't hear you either. It is statutory interpretation. Was that a whole... how many weeks of that did you do? Or was it a whole course? I'm not that familiar with the program yet. That was a whole course. Okay. Well, I will try not to bore you too much with it. The problem I found generally in law courses and law programs is that you tend to deal with individual sections of legislation, but you don't deal with legislations as a whole thing. And when you get into practice, you suddenly find you don't necessarily have a textbook to look to, and you don't necessarily have some nice extracted sections of legislation that you can go to. You have to understand how it works. And that's something I don't think you really get enough opportunity in law study to do. So we're going to talk a little bit about that now and some of the skills involved in doing that. For me, legislation is kind of like computer programming. It's about creating the plainest, clearest set of rules in an orderly sequence that relate to each other, that aren't going to break. And like a computer program, you don't know what people are going to do with it. One of the advantages of judgments from the judge's point of view is they already know what's happened. Yes, they're setting precedents for the future, but they focus on the present case. They know that they know what's happened. They know how the law applies, or at least some of the different arguments how the law applies for a fact circumstance. With legislation, you're writing something completely open. You're writing an environment for people to come into, and they could do anything with it. So it's this weird process, and I think you have a subject on drafting that you might do some of this in, but it's a weird process of second guessing and trying to build something that's not going to break, that doesn't have loopholes, and that you can hopefully predict how it's going to evolve and develop over time. The other thing is, as it's almost like computer code, each piece of legislation is like a little machine. It has a whole series of systems and subsystems that operate in interconnection with each other. And once you get a feeling for that, you get to understand how the whole thing works. So what do I mean by all of that? Well, if you have a look, and I've recommended that you get a print copy of the Succession Act, because I really do think the only way to learn to navigate is actually to physically get into a physical copy. I find that an electronic copy, you scroll up and down, you don't get a sense of where things are, and it's difficult to... Maybe that's just me being old-fashioned or something, but I do find, I don't think I'm a Luddite, and I do find that it's very difficult to deal with like a PDF of a piece of legislation and to see how the system works. Okay, so one of the problems of seeing an act as a system is that it's sequential. It's just a list of one after the other of all the sections. And the first thing I do when I approach a new piece of legislation that I need to understand is I break it down into its components. I break it down into its parts. So the index will help you because they're usually grouped together into parts, but not in a way that's very visually accessible, usually just as a list. So I'll see if I can... You don't need to be able to read this, but hopefully you'll be able to see the kind of thing I've done here. Okay. What I've done is I've broken the Act into its parts, and I've made and its subparts, its divisions within those parts, and the key elements within those parts. So you do whatever works for you.
Is my microphone working now, Scott?
Yes, it is. Much better.
Okay. Thank you.
So yeah, that's the first thing I do, is to try and get a feel of how the pieces relate to each other and what they all do. And as you get to understand the genre of legislation, you'll find that they're written in fairly similar ways. There's a kind of, it's like, what makes a Western or a romance a romance? What makes an act an act? They all share DNA with each other, really. And you'll also find that acts tend to have a lot more space devoted to operational materials than to what they actually do. So some actually even find there's like 1 or 2 sections that actually says this is what the law is, and then you've got 20 or 30 pages of, and this sets up the office of whoever looks after it, and this sets up what their powers are, and so on. And you'll find there's a bit of that in the Succession Act too, that the operational parts, the parts of actually creating the bureaucracy and administration to make the law work, are usually much bigger than the law itself. And sometimes the law itself can be surprisingly brief. It can just be a little section there. Okay, so.
Excuse me, Scott?
Yeah.
I was going to say but what I wanted to say before was, the course that we did last semester, I think we all did it, was the Advanced Statutory Interpretation and Drafting course. And that actually was really in depth, and part of the actual course was to draft our own piece of legislation. And it actually contained quite a lot of useful information. And the last week was around wills and the wording of them. So it was really good. That's
handy. Okay. Well, I won't. I mean, I'm not going to go into any of the interpretive rules or anything either. But hopefully, this is something you guys are familiar with. Although I think that is an elective unit now, so I can't really assume that everyone will have done it. So in terms of the Succession Act, what does it actually do? What's the machinery of it? How does it actually work? Well, the key part of it is really Part 2, which is the section that's all about wills. I mean, if we look at what the sections are in sequence, first is the preliminary section, which is definitions and everything else. Although it does have an interesting section there on how a spouse is defined, which sends us off to the Acts Interpretation Act. And I must admit, I haven't followed that link in Queensland, so I must have a look at what the Acts Interpretation Act says a spouse is. Section Part 2 is wills, and it's actually the operational stuff about making, interpreting, and the powers that the court has in relation to wills. Section 3 is on intestacy, which has a whole section for itself. Section 4 is on the family provision section, which has been inserted in there as a completely separate mechanism. And I think it's quite interesting that from a design point of view that wasn't stuck in the court's powers. Because another way of doing this would be to have actually put the family provision element in Part 2, Division 4, I think it is, where the court's powers are, to say the court has the power to make orders in respect to the following. It's actually got a whole section, a whole part on its own. And when we come to cover that, we'll look at that in more depth. Part 5 is on administration, so it's powers of the probate process and the powers of personal representatives. And Part 6 is MISC, of course. So that gives us an idea of what it does overall. What we're focusing on really tonight is Part 2 and the sections there, particularly on the court's powers and the altering, the powers around altering and sections of wills. I did have something else to say about legislation. Oh yeah, the other thing that's it's a really strange mindset to get into in legislation is that most acts have been amended so many times, is having that consciousness of which bits have amended and which bits haven't been. And that becomes really crucial when you get to looking at the common law. Because very often it's a very easy mistake to make, is to argue a particular case on a particular area of legislation, and then for someone to say, well, actually, that's on the previous section, and the Act was actually amended in 1994, and it's changed now. So being able to keep track on where amendments occurred, is vital and not the easiest thing to do. There's a schedule in the back that looks at amending acts, and it becomes very, very crucial to, and not all acts have this, it's good the Succession Act has it, not all acts have it, to be able to say, okay, check the section in the back, check when it was amended, check the date of the authority you're relying on, and then check the authority to make sure that it's not been altered by that amendment. So that again is something tricky to do. Okay, so I just thought I'd do a bit of a preamble on legislation. It's fascinating in a very boring kind of way. And I think part of the problem is we teach it in little chunked up pieces and we don't spend enough time looking at the big picture. So in terms of the question for the workshop tonight, I guess I've probably got the part A and part B of the question around the wrong way. But let's start with part B. So where in the Act does it set out the obligations to read a will strictly? So we're looking at the difference between a strict reading and a reading where the court says, oh, look, we can probably change that and fix that and alter that. So where in the Act does it set out the strict readings? You can type or have a bit of a quick look. Another reason why print version is good is if you're on a video conference, you can look at the print. So any ideas? Well, let's jump straight to it. Section 10. How a will must be executed. And you look at the language in section 10 and it says, this sets out the way a will must be executed. A will must be. This must be. This must be. So if you look at the language in section 10, you'd be forgiven for thinking that we were still in the Victorian era of wills. Where it was set in stone, it was almost like constitutional law. Interestingly enough, it does have some modifications in there, like it says signatures need not be at the foot of the will, and that used to be a rule that they had to be at the bottom, because back in the day, before computers, etc., they were concerned that people could add extra clauses. Like if you signed it with a gap in the bottom, people could add extra things down it underneath. So that used to be a rule, not a rule anymore. So there's this. Yep.
Quick question, just on that note, because the community legal service was telling me about a month ago now that you used to have to do a will in a particular colour of pen, but that's been changed now as well.
Yeah, I don't think that's ever been law. I was talking to someone who had a similar problem in Victoria where their mother's will actually got contested and there was all kinds of costs in probate because people signed in a different pen. And I haven't been able to find any authorities for this. The authorities are all around whether I guess they're saying that that's evidence of the witnesses being there at the same time. And if they used the same pen, of course they were there at the same time. They couldn't possibly pick a pen up later and use it. So yeah, this actually came up for me as well, and I couldn't find any legal foundation.
Because she was telling me that you used to have to use, it had to be a black pen and the blue wasn't allowed.
Quite. The other thing is with probate judges are a creature of their own because they only deal with probate. You probably have like individual judges who have weird practices and things as well. And yeah, I mean, we used to be a lot more formal with things too, is also part of it. And you get that in contract law as well. So I was kind of curious about some of this stuff, of what the legal foundation of it was, that if people actually went to court. And I guess what it would be is there is an assumption. It's not even as strong as an assumption, but the prima facie position is the will is duly executed, and then if you want to challenge the will, you have to raise a suspicion. And if you saw that there was a red and a green pen on the witnesses, you could try and argue that that was a suspicion. But given the court has the power to basically rewrite the whole will, so it seems, I wouldn't think that would be a problem. The other thing, but as a matter of practice, I guess that's where your expert tips come in. As a matter of practice, do make sure they use the same pen, just in case. And I guess legal practice is nothing but a series of exceptions to rules and things to bear in mind. The other one, I studied succession in an era when witnesses couldn't be beneficiaries. The current position is it depends, and it's different in every state, and the states have kind of finicky provisions as to whether witnesses can be beneficiaries or not. So the general rule, I think, there is don't have witnesses as beneficiaries. Yes, there may be some situations where you can have a witness that's a beneficiary, but why risk it? Why even risk it? There may even be problems with if you're a solicitor and you execute a will, whether you can get costs if you become if you become the executor under the will. Okay, you can put a clause in the will that says that you can recover reasonable costs from the estate, and there are different cases on whether or not that's valid or not, whether you can witness that or not. End of the story is solicitors just get colleagues or their paralegals to witness it, or pop in next door and get someone from next door to come in and witness it. Whatever, just don't run the risk. I guess is the thing at the end of the day. So yeah, interesting you should hear that. I think it might be the equivalent of a legal urban legend, but I'm prepared if someone was to actually point out the case that says that, I'd be prepared to swallow my pride on that one. But I don't think so. And again, this is another one of those deeply contradictory areas of law, because there is a case, it's in your readings either this week or next week, where someone was in hospital and the nurse got called away in the middle of witnessing, and it's an incredibly pedantic decision on whether the nurse, basically there was the nurse and a patient witnessed the will. In the middle of the witnessing process, the nurse got called away and came back, and the witness, the testator had signed the will and the other witness had signed the will. Now the general rule is you don't have to be in the presence of the testator when they sign, but they can indicate, they can say, that is my signature. As long as you witness that, it's okay. But because one witness had actually witnessed the signature and the other witness got told that that was their signature, this created a problem, and then the will was invalid. Now, I can't imagine that happening again. The circumstances are weird to start with, and it seems an unrelentingly brutal precedent to make on really splitting hairs. It's gone from my brain what the name of the case was. So these days, and we're going to come to this right now actually, the courts can cure pretty much any defect in the formalities of a will, as long as they think that it's the what the testator would have wanted, so they can save those sorts of wills. Anyway, so Section 10 is the must provision. The question is, where are the situations where courts can avoid the strict reading of a will, particularly if the strict reading would make it either an invalid will or make a particular gift invalid. So where have you come across in your readings what sorts of powers do they have, and where are they?
Well, Scott, I looked at section 33. The court may rectify a will.
Yep, that's one of them. So, section 33, 33A. We'll look at them. We'll look at each of them in depth in a sec. I guess we'll talk about what they are. That's where there's a mistake, and the courts can come in and can fix, basically fix a mistake that they think is a clerical error, and that will save a will. We're going to look at construction of interpretation of the will in a couple of weeks' time, and it may be that in the rules of interpretation, so not in the legislation, just in the rules the courts use, they can almost do this anyway. So they have the power to do it, and in practice they kind of, work around things that are clearly errors or misspellings and so on. Okay, so where else is there power to read outside the strict words of a will?
Section 18.
Section 18, yep, which is the dispensing powers, which is where the formalities of the will are have got a problem, like you might have been witnessed in a different coloured pen or not, and that gives the courts what we call the dispensing powers, the power to dispense with the formal problems. And there's one other situation that's a relatively recent one where the courts can read outside of the strict words or formalities. Anyone? Statutory wills? You might not have gotten that far in the readings. So Part 4, Subdivision 3, Sections 21 to 28 deal with a situation where someone actually doesn't have the capacity to make a will, either because they're a minor or because they're suffering from mental incapacity, or they might be phasing in and out of capacity, and that actually gives the court the power to create a will in those circumstances. And what is typically done is that when this typically happens is when there's a will that looks valid. They can do it. They can just make a will up if they've got any evidence of what the person wanted. And sometimes, if it's not controversial, they'll do that. Particularly if it's a minor who's involved, that's property. But the typical situation is someone who may lose capacity. So particularly someone who's suffering from Alzheimer's, and there may be a will and it may be changed, and there may be doubt as to whether or not they had capacity to make it. If the court's satisfied that it's probably the kind of will they could have made, they can use Subdivision 3, Sections 21 to 28 to remedy those problems with the will. So we've got basically three key areas that the formalities, the strict words of Section 10 give way to a much more liberal approach.
Scott?
Yeah?
I was just wondering, are you, would you be able to get onto the library? I know they've done it in other courses, and would you be able to make available a scanned copy of that chapter 4? Because I've got an old copy of the text and I don't have that.
Oh, okay. I will see. And there may be another chapter that you may not have. Let me check. Because the other way, that I may, I'm recording this idiotically, but I may just scan it myself and stick it on Moodle. Just don't tell anyone.
That'd be great.
I'm a terrible lawyer sometimes. The chapter 11 you may not have as well is the family provision chapter.
Yeah, I haven't got my text in front of me, but I did know. I went to have a look at the statutory chapter there, and it wasn't there. So
okay,
If you could do that, that would be much appreciated.
Yeah, I'll do that. And pretend I know nothing about intellectual property law, even though I'm teaching it next term. And it's actually my area. Anyway.
Deny till you die.
Recalling. Yeah, I can deny it, but they've got if they were thorough enough, they'd get this recording, wouldn't they? They use their extensive fair trade agreement powers of corporate search and seizure. Anyway, that's a topic for the next term. Louise has suggested that the nurse-patient case might be recalling. Let me have a quick squiz. It may well be. Yes. I've written pettifoggery next to it in my copy of the text. So it's in the text on my version of the text on page 115, where we're talking about formal requirements in the presence of the testator. It's worth having another read of that. Not because it's valid law, because basically the dispensing powers were introduced because of this kind of thing. But I think it's a really good example of the kind of knots that courts can get themselves into when they've got this tunnel vision where they're just reading the law very, very strictly. So they don't do this anymore, and it's that weird position where we're giving you something in a textbook and saying, this isn't valid law, so read it. But the purpose I want you to think about is not in terms of it being valid law, but the kinds of problems courts can create for themselves when they read things too strictly. Now, I would also argue, I think, that they create problems when they go the other way too. And I think we'll see this pop up again in this course, that there's lots of situations where you read things and there are expressions in the Act that are things like, such as the court sees fit. And that doesn't sound like law to me. That sounds like kind of arbitrary decision-making. And I'm not criticising an individual judge for doing that, but the whole point of the common law system is that we don't, the whole point of rule of law is it's ruled by the law, not by the whims or discretions of individuals. This is the problem many lawyers have when this is slightly off topic, but I don't know if any of you have any dealings with administrative tribunals, administrative appeals, one in Victoria's VCAT. I'm sure there's an equivalent in all the other states. But those tend to be headed by, and when you do admin law, if you've done admin law, this will ring a bell, they tend to be headed by tribunal members who are non-lawyers. So lawyers who argue before them look at sort of technical things like dates and signatures and consent. And you go before these people and you say, this is the fair resolution, and they have no legal training quite often, and they'll just say, well, no, I think the fair thing to do is this. So it's a course, it's a source of, I find admin law kind of fascinating too, but it's a source of a great deal of angst for practicing lawyers. And in the very first version of the Commonwealth AAT, they actually kicked all the lawyers out of the process and said everyone had to be self-represented because of that. And it really highlights to me, yes, that sometimes lawyers can be very pedantic, and yes, lawyers can sometimes take a very lawyerly view of things, but that's not necessarily a bad thing, because your alternative can often be very much very unpredictable. And if you go to one of those administrative tribunals, you quite often are in a position where you say to a client, I really don't know. You could go either way. And, you may end up, residential tenancies go through that. So if you're representing someone on a bond claim, they'll go through that. Development applications go through that. I had when you hear developers talking about how they know how to game the system, and they go into VCAT and say they want to build a 30-storey building next to your house, and you complain, and they say it's okay, we only want to build a 5-story building, and the tribunal often will say, oh, that's fair, you've reached a negotiated solution, okay, and they know how to use that system. Whereas the once-off, because they're a repeat player, the once-off players, who are the people challenging them, don't have that experience, and they end up getting screwed by that system. Anyway, that's a diversion, but I guess part of me is concerned in terms of rule of law that the succession, the way we're going with succession, it's not going to end up that bad, but it creates concerns for me that that there is a lot of things that are being done on individual discretion rather than following rules. Not when you think I'm a rules Nazi or anything, but systemically I think that's a problem. Okay, getting back on track. So we've got the rectifying mistakes, we've got the fixing problems with formalities, and we've got the lack of capacity. Okay, so rectification, that's section 33. Here's a fantastic example of that point I was making. The court may rectify a will. The court may make an order to rectify a will to carry out the intentions of the testator. If the court is satisfied that the will does not carry out the testator's intentions because A, clerical error was made, B, the will does not give effect to the testator's intentions. So that says the court can change a will if they think it doesn't give effect to the testator's intentions. I don't know about you guys, but that sounds extremely broad to me. I know most probate judges would probably be a bit cautious about. They wouldn't be using it in a willful or whimful way, but I think it's something to be cautious about. And next week, the workshop, we're going to talk about power and gender and culture, and we're looking at that in the context of ideas of undue influence and how the court, whether the courts are sort of culturally or socially literate enough to be able to tell those things. I would suggest it's the same. It could be the same problem here. I'm not 100% confident that all the probate judges have enough cultural competence to make these kinds of decisions necessarily. And I'm sure if evidence was brought before them that this is the way in which we make, this is the culture of the testator, these are the kind of, this ties to your assignment too, this is the kind of will that the testator was going to make, this is what they intended to do, here's some extrinsic evidence, someone maybe can talk about the way gifts are done in this particular community. If it was brought to the forefront, I imagine many judges would be aware of that and would listen to it. Where it's a problem is where they don't know what they don't know. They're not necessarily alert to those things. And then you've got that interesting problem where you've got the judge's own presumptions about how things work influencing the kinds of decisions that they make. So I don't think it's a burning issue with the system, and I understand why we've got all these powers to fix it, but I can also see there will be circumstances where judges will be fixing things on what they assume is the problem and what they assume someone's intentions are. And yeah, I don't know what you guys think about that. But I think it could be kind of problematic. And, cultural competency is one of the things we need to talk about more in this program because it's part of our threshold learning outcomes, which is something I'm sure you're terribly fascinated by, but one of those things that we say to the admitting bodies that we deal with cultural competency in this program. Okay, so we okay with section 33? mistakes or any other reasons why the courts may want to change? I'm conscious of the time getting away from us a little bit. The next section that we were talking about was the dispensing powers, section 18. So this is nested within the division on the court's powers, and the section is execution requirement. So it's basically the court has power to execute a will if it's not executed correctly under the law. This is another really awkwardly drafted section. So 18 section 18 subsection 2. So this is dealing with a document that purports to be a will that isn't a will because it's not executed. This one takes a few reads to get across, and I've been reading very. My reading hasn't been great tonight. So section 2 says the document or part forms a will, an alteration of will, or a full or partial revocation of a will of a deceased person. So it forms that if the court is satisfied that the person intended the document or part to form the person's will, an alteration to the will, or a full or partial revocation of the will. So any of those things, the court can say it is those things if the court is satisfied it's what that person intended. Okay. So to help us out with that, subsection 3 says the court can look to any evidence of the way the document was executed or any evidence of intentions. So this really opens the door to bring a lot of extra documents or testimony from individuals into consideration. Okay, so again, if you are thinking that section 18 is got an awful lot of discretion in there and doesn't give you much guidance as to how to exercise that discretion, you'd be right. And in practice, it's all about producing that particular evidence of what those intentions were. In practice, I think it's usually the situation where the court is on the face of it valid, but there's just something silly that's wrong with it. So the Collings case is an example of one that was quite a complicated, weird, unlikely to occur again set of facts that created a problem. But as Daniel said earlier, you can also have that situation where people are casting doubts because the pen the witness has signed in is a different colour. They use a different pen to sign it. What section 18 does is it gives the court the power to say it doesn't matter. We've got enough evidence that this is, even if we did decide that the will was not valid, was not properly executed, we've got enough evidence here that this thing that isn't a will is their intention, so we're going to turn it into a will. We're going to use our court powers to do that. Problem with that is it's not cheap. You've got to make an application to probate to do that. So it's not like it's not something you can do trivially. However, I guess if it's the difference between you getting a gift under a will and not getting a gift under a will that's substantial, you'd be using this section to do that. So are we okay with the dispensing powers? The final sort of will fixer-upper section is the statutory wills. So it's just over the page in subdivision 3, persons without testamentary capacity. And again, if you don't have capacity, it gives the court the power, the ability to create a will for you. They don't necessarily validate a will you've attempted to make. What they do is they create a will for you, but they use the will. Generally, someone's attempted to create a will, they will use that as the template to say, we think the best evidence of their intention was this thing that they have, that they called a will, that they tried to execute as a will, but they weren't able to because of capacity. There's only situation where that's, well, not the only, but the situation where that's generally different is where there's someone who has no capacity at all. Like, for instance, someone who's in a coma. They can then use these powers to create a whole will. And generally when, I shouldn't make generalizations, but I think generally what that happens is there's no, it's not controversial. It would be it would be more difficult. They might fall back on intestacy if it was controversial, but you might be in a situation where there's a young person who's in a coma. They haven't got the ability to make a will. Their parents are looking after them. They have some resources. Rather than it going to intestacy, the court may then create a statutory will to say, we'll give all the we'll just do a basic will giving all the property to the parents. Although I think that probably happens under intestacy anyway. So there you go. But that would be the kind of circumstance where they would create a whole will out of nothing, is where someone had no capacity at all. But I think most situations is where someone has doubtful capacity, seeks to create a will. Now, if that new will, if someone who's lapsing into dementia, the new will seems odd or strange, they're not going to necessarily create that as a statutory will. But if it's similar to previous wills that have been revoked, then that's the situation where they may well just say, okay, we'll create a statutory will. So the difference between that and fixing the formalities is sometimes technical, and sometimes it's just a question of which way you go on it. But at the end of the day, we've given the courts lots and lots of power to get in and fix these things up. Now, is the pendulum going to swing back? There's been a lot of law reform in this area. There's been a lot of activity and a lot of changes over the years. Are we in a situation where at some point the courts go back the other way? Not sure. It may be that this system works. Basically, most wills just get put into probate, they get executed, they get processed, challenges get dealt with and resolved. Maybe this is just how this area of law works. But it's something to keep an eye on, and I think it's something that's it's one of those interesting topics that come out of this course. Okay, so I'm conscious of I'm still available for a while now, but I'm conscious that some of you guys have to go. Chance for questions. If you're happy as you can be with legal coursework. Okay. So, as I said, next week, all the way from exotic and remote New Zealand, we're going to have a look at the undue influence sections, and we're going to use that and possibly some of the things we've talked about this week as a springboard to really think about, to dig under the surface of those very simple concepts where the law talks about what intention is and how does the court know and what a person's intention is. Do they just assume? There was the case where someone, I forget which one it was, where she cut we looked at it last week, she cut her son out of the will, and Justice Kirby said, yeah, that's fair enough, and he was dissenting as usual. But the other judges just said, you don't cut your son out of a will. That's just not on. And you think, well, that says probably more about their assumptions than it does about this particular individual in that particular case. So in the big picture, how are we going as a legal system in terms of understanding those power differentials, particularly when we're talking about things like undue influence. And as practitioners, what do we have to be aware of? What sorts of things, when someone comes into the office and says, this is the will I'm making, and I'm making it of my own free will, what do we keep an eye out for? What sorts of things may create problems further down the track? And family violence is one of those issues that I think we should zero in on with that, because that's an area where clearly we clearly there's a potential for undue influence, and clearly it's never ever argued. It doesn't seem to come out in the courts. All right. So if there are no more questions, happy to talk about anything or talk about the assignments or anything else. But if not, all good. Great. Talk to you all next week.
Thanks, Scott.
Thanks, Scott.